It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Now that I got your attention, I guess I should probably mention I got a new album available now on my site. Nigga, fuck all that whining and bitching. You looking for greatness, then I'm the description. Dropping me by like a prison. Twisting your brow like ignition and split, nigga. That's what I call on the vision. I'm finna infiltrate, you cannot imitate. I'm from a pedigree, this is not Triple H. I took a road, you can't travel like Triple A. Do the impossible, just like a triple play. Genuine energy, I am not Timberlake. But a nigga too insane. Truck for the money, but to pull up in the ring. So I can give a what the fuck about what a nigga think. I'm on some new shit. Elevated my rubric. I'm an industry nuisance, giving my 2 cents. Telling niggas what the truth is. It ain't even about music. Everybody wanna know the cheat code. Bitch, I got bops on reload. I was just on live 2 hours straight. Ain't playing not one repeat song. I'm ready for the spotlight. I was on the block like a stoplight. Every day I catch lightning in the bottle. The niggas told lies, but not hitting spots twice. Couple years I was living on fried rice. Like a tree when I got to eat Popeyes. Gotta feed 'em and get your whole top 5. Spit heat on top like a rabbi. It's no. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there. Of course, in this video, we're going to be giving an update on Megan Thee Stallion in her legal situations. Of course, we know that Emilio Garcia, aka Emilio Cucci, her former cameraman, issued a lawsuit against Megan Thee Stallion last year in which he claims that she sexually harassed him, brought other forms of harassment against him, discriminated against him due to his sexual orientation as he is a gay man. And he also claims that there were unpaid wages and overtime and all of these different things that he was owed after she fired him, okay? So we're going to give an update on that because, of course, Megan Thee Stallion has been fighting for a year to try to get this case dismissed. Unfortunately, it was not dismissed, but there are pieces of his claims that have been dismissed. All right. It will move forward, but that does not mean that his lawsuit will necessarily be successful. It's just that it's moving on to the next stage, which will probably bring forth a trial. Okay. Now, in the midst of all of this going on, we also have Nicki Minaj, who's taking to social media to throw shots at Megan once again, and she's continuing to throw shots in Jay-Z's direction. Of course, we know that she is vehemently against Jay-Z, Roc Nation, Desiree Perez, and anything and everyone that's in that circle, including Megan Thee Stallion. So this is not much of a surprise. She's been throwing, subliminals out for weeks. But as I told y'all before, I really don't cover Nicki Minaj unless she's sending direct shots. I really don't have the patience to try to decode the things that she says on Station Head and all of the little language and things that she says amongst her fans. But if she says something directly at somebody, we'll cover it. Whenever she decides to drop music and get off the internet, we'll cover that as well. But as of today, she took some direct aim at both Megan and Jay-Z. So we're going to cover that here as well. But first, let's get to the specifics of the judge's order in Emilio Garcia's lawsuit so that we can understand the status of this case and where things will go from here. And, just in case there's any misinformation that's being disseminated via the internet, we can kind of get to the bottom of what's really at stake here, what Megan is going to have to face moving forward, etc. Okay? Sound good? Bet. Now, interestingly enough, this information was actually put out almost a week ago, but it's just now hitting the scene. This is the judge's order, memorandum, opinion, and order. This was filed on the 2nd, so right before July 4th weekend. This was already filed, but many of us missed it, so it went and hit the scene yesterday as I'm guessing the press got a hold of it. Okay, so this is Emilio Garcia versus Roc Nation and, of course, Megan Thee Stallion. Gregory H. Woods is the judge presiding over the case. So it states here, introduction, Emilio Garcia worked as a cameraman in rapper Megan Thee Stallion's entourage. Mr. Garcia traveled with the entourage all over the world and worked long hours. He alleges that as part of his duties, he was required to attend strip clubs. He also alleges certain lewd and abusive behavior directed at him from Megan Thee Stallion herself. Mr. Garcia asserts 19 claims against Megan Thee Stallion and the corporate entities that he alleges employed him, as in Roc Nation. The claims include wage and hour violations, hostile work environment, and retaliation under California and New York law, not to mention Hot Girl Productions and her other legal entities that she has under her belt, her companies. Defendants moved to dismiss plaintiff's claims for failure to allege facts sufficient to state a claim under the laws of California and New York. The court holds that plaintiff fails to allege facts sufficient to plausibly plead a California hostile work environment claim. So, number one, the judge says that the hostile work environment claim for California is not sufficient. Okay? Overtime and notice claims under California law, overtime claims under New York labor law, and aiding and abetting claims against the corporate entities under the New York human rights laws. Okay, so all of those claims are going to be tossed. Now, for the things that they are going to move forward with, plaintiff adequately pleads a meal and rest break claim under California law, retaliation under California and New York law, and discrimination under the New York human rights laws. Therefore, defendant's motion to dismiss are granted in part and denied in part. Okay, so this is not a black and white situation. Part of his claim is going to be thwarted and part of his claim will move forward. Okay, as they get into the background, and it's not Hot Girl Productions that's being implicated here, it's Hot Girl Touring, just for accuracy, right? Megan Thee Stallion Entertainment, Roc Nation, etc. We don't need to go through that. All right, so 2, plaintiff is hired by defendants and joins Pete's entourage. So in 2019, plaintiff was hired to serve as Pete's personal cameraman. This was in his claim. This was a full-time position. Plaintiff was classified as an independent contractor during his time working for defendants, but plaintiff alleges that he did not provide personal cameraman services independently of his relationship with Pete. Pete specifically told plaintiff he was not allowed to service any other client other than herself. All right. So moving forward, they're probably going to have to try to prove that in court that she was not restricting him from working with others. We'll have to see about that. Initially, plaintiff was paid a monthly flat rate of $4,000. Because he was classified as an independent contractor, he did not receive health insurance coverage. Plaintiff had to travel with Pete and her entourage as part of his duties. Plaintiff did work for defendants primarily in California and New York. On average, plaintiff was in New York at least once per month and sometimes remained in New York for weeks at a time. And typically when we see Megan Thee Stallion in New York, it's for meetings and business planning with Roc Nation. While traveling with Pete, plaintiff was required to stay at the hotel and be on standby at all times. Be ready to work. Plaintiff essentially worked during all waking hours of a day and worked in excess of 50 hours per week, but plaintiff was denied overtime pay at an overtime rate. Defendant also maintained inaccurate work records, which did not properly record plaintiff's work hours. Okay. So they're saying that, unfortunately, Megan Thee Stallion did not properly log in what type of hours he was working for her. Pete controlled and directed the work performed by plaintiff. More than once, Pete would interrupt plaintiff during dinner and demand that he immediately shift his focus to assist with her TikTok creative ideas. Pete continuously contacted plaintiff at all hours, directing him to brainstorm TikTok videos, to edit content that plaintiff had not captured, and to complete various assignments. Plaintiff was denied a meal break or rest break and was never paid meal or rest break premiums during his entire employment. These are his claims. Plaintiff was required to not only take photos, videos, and edit content, which was all done under the strict control and direct supervision of Pete, but also to accompany Pete almost anywhere she went as part of her entourage. I mean, that is what a cameraman does for a celebrity, especially a high-profile one. The entourage included Pete, plaintiff, dancers, makeup artists, nail techs, and others. Pete was perceived as the leader and all others subservient. I mean, she paid everybody. Members of the entourage were unable to spend their time for their own benefit and were present only to attend the needs and demands of Pete. As a result, plaintiff was afraid that Pete would retaliate against him if he refused to acquiesce to her every demand. These are all his claims. Pete put plaintiff in uncomfortable situations. As part of Pete's entourage, plaintiff was required to attend strip clubs, nightclubs, and other excursions. Pete compelled plaintiff to go on dozens of trips to strip clubs in New York, California, Atlanta, Georgia, and overseas. Plaintiff attended strictly out of his duties to his employer, not for his own pleasure or benefit. I mean, that's what you do when you work for somebody and you have to travel. Don't see how that is an issue. On one occasion, on or around February 15, 2022, plaintiff and the entourage were required to accompany Pete to a New York City strip club. Plaintiff went to the strip club only because Pete required him to. You had already been doing it for 3 years. What's the problem? At one point in the evening, Pete began physically touching the dancer in a sexually provocative manner, which made plaintiff feel extremely uncomfortable, embarrassed, and disgusted. So Megan is having a good time. He claims that she starts touching the dancer, maybe slapping her ass or something. Who knows? I can't say what exactly happened. But at this point, he began to feel disgusted, allegedly. Plaintiff tried to avoid the situation, but was unable to leave. Later in the evening, plaintiff made a joke about being related to one of the dancers who shared his last name, and Pete shot plaintiff a sinister look. A look, people. Eventually, plaintiff removed himself from the situation and proceeded to leave the strip club and wait in one of the SUVs in the convoy, waiting for Pete and entourage. In or about June 2022, plaintiff traveled with Pete to Ibiza, Spain. One night during this trip, plaintiff was required to join Pete and the entourage to a nightclub in Ibiza. After leaving the nightclub, plaintiff and Pete, along with 3 of Pete's female best friends, got into an SUV. Plaintiff was only present in the SUV to perform his duties as Pete's employee. The SUV had 2 bench seats that allowed the passengers to face each other. Pete, who was allegedly intoxicated, proceeded to engage in sexual conduct with her friends in the SUV. Plaintiff was unable to remove himself from the situation. The sexual conduct taking place in front of plaintiff made him feel extremely uncomfortable. Okay? These are his allegations being laid out by the judge. Later that same evening, plaintiff, Pete, her friends, and other members of the entourage were having dinner at the residence where they were staying. Suddenly, plaintiff felt Pete was giving him a dirty look once again. So, out of all things, her just looking at him in a certain way made him terrified, I guess. Suddenly, plaintiff felt Pete was giving him a dirty look once again. Pete shouted at plaintiff so everyone could hear, "Are you really eating that, you fucking fat bitch? Spit that shit out," is what he claims Megan said to him. Pete continued, "Why are you still chewing? Spit that shit out." Pete then grabbed the food off another employee's plate who was sitting closer to Pete than plaintiff was and threw the food over her shoulder. Humiliated and ashamed, plaintiff excused himself and proceeded to go to sleep for the night. Plaintiff had informed Pete that he had an eating disorder and struggles with weight. So when she called him a fat bitch, apparently that was extremely offensive, allegedly, if it really happened. The next morning, plaintiff made it clear he did not appreciate and opposed Pete's unlawful conduct in the SUV. Pete responded, "Don't you ever speak about what happened in the car." Okay? The conditions of plaintiff's employment changed. Prior to the Ibiza trip, defendants booked plaintiff regularly, frequently every week, and sometimes for 7 days a week. After the Ibiza trip, however, defendants began to request fewer services of plaintiff, relying instead on other photographers. Now, what I find to be very interesting here is it seemed that you already were not enjoying yourself as she was going to these strip clubs and going to these different places. Seemed like you wanted to be around less. So when she decided to start working with other photographers, why is it such an inconvenience for you other than financially? But you didn't want to be there anyway. You said you were only there to conduct your duties, which you seem reluctant to want to be a part of anyway. So her booking someone else should have been a relief. But I will continue. This change had a direct impact on plaintiff's compensation. The financial consequences notwithstanding, Pete forbade plaintiff from working for any other celebrities or from working elsewhere. That will be determined at a later time. Okay? In August 2022, plaintiff was with Pete and the entourage in a hotel room in Portugal. While others were partying, plaintiff sat down and placed his head on a pillow. Suddenly, a TV remote was thrown at him, hitting plaintiff in the head. Pete was standing in the direction from which the remote came and shouted, "So what if I did throw it? Then what? What are you going to do about it?" So he claims that Megan Thee Stallion hit his ass in the head with a TV remote and then proceeded to antagonize him. Around August 2022, defendants also altered plaintiff's compensation structure from a monthly rate to a pay-per-task system for each assignment. Plaintiff was informed of this change by Desiree Perez, the CEO of Roc Nation. Plaintiff was still expected to provide the same level of service to Pete. Despite being expected to work for the same amount of time as before, the new invoicing system resulted in plaintiff earning significantly less because the invoiced amounts did not accurately reflect the true time and effort dedicated to working for her. Now, we did see paperwork and emails about that particular incident where Desiree Perez basically was telling him he would not be paid the same amount because he was not doing the same amount of work, right? Megan was paying him $4,000 per month for all of his work, but that was primarily because he was traveling with her. But at a certain point, he started taking more time away from the group, right? He was not traveling with her. Therefore, she was hiring other people to shoot for her, but still using Emilio for editing. So they decided if we're only going to be using Emilio for certain editing tasks, then we will pay him at the rate of an editor rather than for everything else that he was doing before. For this reason, they wanted Desiree Perez to be deposed, which they have been trying to not have her be deposed because she was only acting on Megan's orders, which means Megan should be, be able to satisfactorily say what that was about without Desiree necessarily needing to be there. All right, we'll continue. Plaintiff's work assignments continued to taper off into 2023, but he was still forbidden by Pete from working for anyone else. Plaintiff was excluded from this Europe trip, was not compensated, yet was prohibited from working elsewhere. Okay, now this is where he gets fired. Defendants terminate plaintiff and interfere with plaintiff's future job prospects. In 2023, plaintiff confided in one of Miss Pete's former makeup artists, Alex, about the unlawful pay practices associated with his work for Pete. Then in June 2023, plaintiff received a call from Alex's phone. Pete was on the other side with an angry look. This is angry look number 3. Pete lashed out saying, "Bitch, you want to fucking quit on me, ho? You want to quit on me, bitch?" Plaintiff explained that he did not want to quit, but that he wanted to work in a respectful environment and be paid all of the wages owed. Okay, so he was voicing grievances with another one of, Megan's, I guess you could say employees or contractors, however you want to deduce it. He was complaining. Word got back to him that he was complaining, and she confronted him. Now, if she indeed said these things in this particular language, I don't think that's the most professional thing to do, but they were also friends outside of work, which is pretty much not necessarily detailed in this paperwork. So perhaps that was the reason why she spoke in these terms. But we'll continue. Pete continued to yell at plaintiff and call him bitch and hoe, telling plaintiff that his boyfriend made him lazy. Okay? So he's alleging that Megan is now shaming him for having a boyfriend because he got your head out the motherfucking game. Pete blamed the corporate defendants and said that it was Roc Nation who books her people, not Pete. So he's claiming that at some point Megan decided to take liability off herself and blame Roc Nation as to why he wasn't being used. Shortly after the June 2023 phone call, a representative of defendants contacted plaintiff to inform him his services were no longer required under purported change in creative direction. They fired his ass. In August 2023, plaintiff was hired for a 3-day photo shoot in Los Angeles, California, but the day before the shoot, the production company removed plaintiff from the project without explanation. Plaintiff subsequently learned that the shoot was for the music video of a song featuring Pete, which was Bongos by Cardi B featuring Megan. Upon information and belief, Pete interfered with plaintiff's contract and blackballed plaintiff among celebrities and performers, making it impossible for him to work in the entertainment industry ever again. Plaintiff has been unable to secure comparable employment like he had with defendants. So ever since he's been fired by Megan and Roc Nation, he hasn't been working at the same rate. I guess that's their fault. Okay? Now, I'm going to skip some of this procedural history stuff because I ain't got all night to be reading this shit. This is 37 pages, people. But this is basically the activity that's been happening in the docket from the original complaint to the motion to dismiss to the amended complaint to where we are today. All right? Here the judge speaks on legal standard. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. It is not enough for a plaintiff to allege facts that are consistent with liability. The complaint must nudge claims across the line from conceivable to plausible. Okay, conceivable to plausible is interesting because when you think of conceivable, that means that you can think of it, but plausible means that it's, a possibility, which is hard to kind of differentiate in simple terms. To survive dismissal, the plaintiff must provide the grounds upon which his claims rest through factual allegations sufficient to raise a right to relief above the speculative level. Determining whether a complaint states a plausible claim is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. The court must accept all facts alleged in the complaint as true and draw all reasonable inferences in the plaintiff's favor. However, threadbare recitals of the elements of a cause of action supported by mere conclusory statements, do not suffice. A complaint must therefore contain more than naked assertions, devoid of further factual enhancement. Pleadings that contain no more than conclusions are not entitled to the assumption of truth, otherwise applicable to complaints in the context of motions to dismiss. On a motion to dismiss, a court must generally limit itself to the facts stated in the complaint. In that context, a court's task is to assess the legal feasibility of the complaint. It is not to assess the weight of the evidence that might be offered on either side. Interesting. The purpose of Rule 12b-6 is to test in a streamlined fashion the formal sufficiency of the plaintiff's statement of a claim for relief without resolving a contest regarding its substantive merits. The rule thus assesses the legal feasibility of the complaint but does not weigh the evidence that might be offered to support it. Discussion. The amended complaint does not rely on impermissible group pleading. The court declines to dismiss the amended complaint on the basis that it relies on impermissible group pleading. Federal Rule of Civil Procedure 8A requires a short and plain statement of the claim showing that the pleader is entitled to relief. Rule 8 imposes a lenient standard for pleading. Specific facts are not necessary. The statement need only give the defendant fair notice of what the claim is and the grounds upon which it rests. Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. That is, nothing in Rule 8 prohibits collectively referring to multiple defendants where the complaint alerts defendants that identical claims are asserted against each defendant. Okay, the amended complaint adequately gives defendants notice of plaintiff's claims and the grounds on which they rest, while defendants identify scattered instances in plaintiff's 54-page complaint of what they call group pleading, which historically has been confined to fraud cases. These allegations are not so imprecise as to deprive defendants of fair notice of the claims against them. Plaintiff specifically identifies the conduct that he alleges created a hostile work environment and constituted retaliation, and plaintiff asserts grounds for violations of wage and hour laws. Unlike in Nesbitt, which defendants cite, the amended complaint generally specifies which defendant engaged in what conduct, while plaintiff does not specify which defendant hired him or which defendant notified him of his termination. Plaintiff also repeatedly alleges that defendants collectively or as alter egos of one another all employed plaintiff and are therefore all liable for the alleged unlawful employment actions. Therefore, there is no question which claims pertain to which defendants. Okay, so they're saying whether it was Roc Nation or Megan, they were working as a team. Sometimes one was giving him information, maybe the other was giving him information, but it's being somewhat accepted that both parties were employing him. B. Plaintiff plausibly alleges that he was an employee of defendants. Plaintiff alleges facts sufficient to plausibly plead that under both New York law and the California Labor Code, he was in fact an employee of defendants, not an independent contractor. So the judge here is stating that Emilio Garcia, although he was a contracted cameraman for Megan Thee Stallion, they are saying he was in fact an employee, not a gig worker. Okay? This is going to be a very vital piece of the judge's ruling. Under New York law, plaintiff plausibly pleads that he was an employee of all the defendants under the NYLL standard. Under the NYLL, the critical inquiry in determining whether an employment relationship exists pertains to the degree of control exercised by the purported employer over the results produced or the means used to achieve the results. Factors relevant to assessing control include whether the worker 1. Worked at his own convenience, 2. Was free to engage in other employment, 3. Received fringe benefits, 4. Was on the employer's payroll, and 5. Was on a fixed schedule. It is not significant how the parties define the employment relationship, they state. Plaintiff alleges that he did not work at his own convenience. Rather, as part of Pete's entourage, plaintiff was unable to spend his time for his own benefit. That's an interesting ruling there. Because he had to travel with her, I guess he didn't have the ability to make his own decisions. But I'm sure if he said he didn't want to come, he didn't have to because he took time off. But I am not a judge. Throughout his employment, his constant availability was required. Additionally, plaintiff had to travel with Pete and her entourage. And when doing so, he was required to stay at a hotel and be on standby at all times. Plaintiff alleges that he was not free to engage in other employment. Miss Pete forbade plaintiff from working with anyone else. Those are his claims. Therefore, they're accepting them on their face, even as his work assignments tapered off. Plaintiff plausibly alleges that he was on defendant's payroll, initially making a monthly salary of $4,000 before his compensation structure was changed. Plaintiff also alleges that he was on a fixed schedule, working full-time for defendant at all hours of the day. Finally, plaintiff alleges that defendant exerted significant control and supervision over the process and results of his work. I mean, of course, he's submitting it to her. Therefore, plaintiff alleges facts sufficient to plausibly plead that he was an employee of the Pete defendants for purposes of the NYLL. All right? So based on New York state liability of him conducting work for Megan, traveling to New York for Megan at least once a month, but sometimes staying weeks at a time, they are moving forward his claims under New York jurisdiction, okay? Plaintiff plausibly pleads that Roc Nation is a joint employer for purposes of NYLL liability. Plaintiff plausibly pleads that Roc Nation is, we just did that. The NYLL's definition of employer is broad, focused on the degree of control exercised by the purported employer over the results produced or the means used to achieve the results. Even when one entity exerts ultimate control over a worker, that does not preclude a finding that another entity exerts sufficient control to qualify as a joint employer. Of course, that would be Roc Nation. Because the statutory standard for employer status under the NYLL is nearly identical to that of the FLSA, courts in this district regularly apply the same test to determine whether entities were joint employers under NYLL and the FLSA. The qualification of a joint employer is grounded in the economic reality rather than technical concepts. The joint employer test is a flexible concept that should be analyzed on a case-by-case basis after reviewing the totality of the circumstances. An entity can be considered a joint employer if it exercises either formal control or functional control over the worker. And Roc Nation, Desi Perez, from time to time, would give him directives from Megan, or at least have directives about his compensation, right? The formal control test asks whether the alleged employer had the power to hire and fire the employees, supervised and controlled employee work schedules or conditions of employment, 3, determine the rate and method of payment, which unfortunately for Roc Nation, they have email of Desiree telling him what the rate would be. Well, not necessarily telling him the rate, but saying we're not going to pay you at this rate. You can propose to us the rate that you think is fair based on editing, and you can, basically confer with your agent or whoever who's managing you. Y'all can come to us with the price. We won't debate it, but it's not going to be the same price that we paid you before, right? So based on that, there's liability. And 4, maintain employment records. No one of these factors is dispositive, nor are they as a whole exclusive. The Second Circuit has held that determining joint employer status is a question of fact not suitable to resolution on a motion to dismiss. Okay? So plaintiff has plausibly pleaded Roc Nation's formal control over his employment sufficient to survive a motion to dismiss on the basis of joint employer status, which means that Roc Nation will not be dismissed from this lawsuit altogether, right? Because that's what they've been wanting. They've been wanting to get the fuck out. Plaintiff alleges that Roc Nation had the power to terminate his employment and to determine the rate and structure of his compensation. Okay, plaintiff alleges that the CEO of Roc Nation personally contacted him to alter his compensation structure from a monthly rate to a pay-per-task system. I just told y'all about that. And plaintiff alleges that it was Roc Nation that reached out to him and informed him that his services would no longer be required. They reached out to him on behalf of Megan to let his ass go. While Roc Nation argues in its briefing that it did not have any rights to terminate the engagement and merely communicated Ms. Pete's decision to plaintiff on her behalf, that assertion is belied by the allegations of the amended complaint, which the court must accept as true at this stage of the litigation. So they're going to take his word for it, and it will be determined in front of a judge and jury. Likewise, Roc Nation's assertion that it merely communicated Ms. Pete's decision regarding compensation is belied by the plaintiff's allegation that when he confronted Ms. Pete about his wages, she said Roc Nation books her people. Now, to me, that is hearsay unless he has direct communication from Megan stating that, but we'll continue. A motion to dismiss is not the proper vehicle to resolve those factual disputes. At this stage, plaintiff has alleged enough facts that suggest that Roc Nation had formal control over his employment and therefore that Roc Nation was a joint employer. Although he was not actually on Roc Nation's payroll, he was not considered an employee on probably their taxes and all of those different things. At this stage, it is being accepted that they were his joint employer. That's what the judge is stating at this point. Plaintiff plausibly pleads that Roc Nation is a joint employer for purposes of NYSHRL and NYCHRL liability. Okay? Plaintiff plausibly pleads that Roc Nation is a joint employer for purposes of his NYSHRL and NYCHRL discrimination claims. So this is for discrimination. The New York Court of Appeals has held that when determining who is an employer for purposes of the human rights law, courts should consider 4 factors. 1, the selection and engagement of the servant. 2, the payment of salary or wages. 3, the power of dismissal. And 4, the power of control of the servant's conduct. Okay, the really essential element of the relationship is the right of control. That is the right of one person, the master, to order and control another, the servant, in the performance of work by the latter. For the same reasons discussed above, plaintiff plausibly pleads that 2 of the 4 factors are met here. Plaintiff alleges that Roc Nation exerted significant control over his dismissal and over the payment of his salary or wages. Okay, therefore, it's going to move forward, and they're going to share liability in the discrimination claim that he has against Megan Thee Stallion, at least moving forward. Now, under California law, it is not clear from the face of the amended complaint that plaintiff was an independent contractor under California law. Under the applicable California law, a worker is properly considered an independent contractor only if the hiring entity establishes A, that the worker is free from the control and direction of the hirer in connection with the performance of the work, both under the contract for the performance of such work, and in fact, B, the worker performs work that is outside the usual course of the hiring entity's business, and C, that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. Now, what I find interesting is that he's a cameraman. He has all opportunity to go work for other people before Megan and after Megan, but they're basically stating that he's not a contractor. He's an employee, which again is a big deal here. All right, let's keep going. Okay, dynamics operation. So this is a case law, blah, blah, blah. Therefore, at the motion to dismiss stage, plaintiff status as an independent contractor must be clear from the face of the complaint. It is not clear from the face of the complaint that plaintiff is an independent contractor under the ABC test. As discussed above, plaintiff alleges that defendants exercise control and direction over his work. Plaintiff also alleges that he does not provide personal cameraman services independently of his relationship with Pete, meaning he didn't really do it outside of Megan. Okay? So this is the interesting thing here of how they distinguish this, because he may not be a personal cameraman for anyone else, but he was still performing photography and videography for people outside of Megan, which means he still had the opportunity to make money off of his camera services. But because he's not a personal cameraman for anyone else, they're lumping him in as an employee, which creates liability for them. That's an interesting distinction. I don't make the law, okay? They say when a worker has not independently decided to engage in an independently established business, but instead is simply designated an independent contractor by the unilateral action of a hiring entity, there is a substantial risk of misclassification. Therefore, it is not clear from the face of the complaint that prongs A and C are met in this case. Indeed, the allegation suggests otherwise. And again, this doesn't mean that this is what will be held to the court. It just means that Megan's going to have to face these allegations in court. She can prove otherwise, but at this particular stage, it's not going to be dismissed. All right. I just want to clarify that. However, because California Lab Code 226.8 does not create a private right of action, plaintiff's 13th claim against defendants for misclassification under 226.8 must be dismissed. Okay. So there's a dismissal there. They say here, C. Kim v. Raines, nor can employees misclassified as independent contractors sue for relief directly under Section 2268. Okay? So this is getting tossed, this piece. Now, let's get into the hostile work environment claims. They say plaintiff has not adequately pleaded a hostile work environment in violation of the FEHA. Plaintiff has failed to adequately plead that defendants created a hostile work environment under the FEHA. California courts have adopted the Title VII standard for hostile work environment sexual harassment claims under the FEHA. Therefore, under this, a hostile work environment sexual harassment claim requires a plaintiff employee to show she was subjected to sexual advances, conduct, or comments that were 1, unwelcome, 2, because of sex, and 3, sufficiently severe or pervasive to alter the conditions of her employment and create an abusive work environment. Again, this is a reference, not necessarily to Emilio specifically, but an example as to why it's not strong enough. To plead a cause of action for hostile work environment sexual harassment, it is only necessary to show that gender or sexual orientation is a substantial factor in the discrimination, and that if the plaintiff had been of the opposite gender or sexual orientation, she would have not been treated in the same manner. Okay? Accordingly, it is the disparate treatment of an employee on the basis of gender or sexual orientation, not the mere discussion of sex or vulgar language, that is the essence of a sexual harassment claim. The objective severity of harassment should be judged from the perspective of a reasonable person in the plaintiff's position, considering all the circumstances. That inquiry requires careful consideration of the social context in which particular behavior occurs and is experienced by its target. The real social impact of workplace behavior often depends on a constellation of surrounding circumstances, expectations, and relationships, which are not fully captured by a simple recitation of the words used or the physical acts performed. Plaintiff concedes that FEHA does not protect non-residents when the tortious conduct takes place outside California. Interesting. Holding that FEHA should not be constituted to apply to non-residents employed outside state when the tortious conduct did not occur in California. So he can't be protected by California law if it happened outside the state of California, basically. Let's continue. Holding that a plaintiff failed to state a claim for relief under FEHA because he failed to allege facts from which the court could conclude that the defendant discriminated against him in California. Therefore, for purposes of plaintiff's FEHA claim, the court considers only the 3 allegations that plaintiff asserts are related to California. That plaintiff was required to accompany defendant Pete to multiple strip clubs in California, that plaintiff suffered harm in the state, and that plaintiff lost work opportunities in Los Angeles due to interference by defendant. First, plaintiff has failed to adequately plead that the excursions to strip clubs in California constituted harassment based on the basis of his sexual orientation. So because he's gay, it does not mean that he endured sexual harassment for having to go to the strip club, because everybody in her entourage went to the strip club. Here the judge says the same. He alleges that the entire entourage was brought to these events, so that would be regardless of sexual orientation or gender. Okay? He does not allege that he, as a gay man, was singled out for participation in any way, that Miss Pete was targeting him by planning these events. Okay? So basically, if she knew that he was against going to the strip club and she made him go anyway, that could possibly be a problem. Especially if he said, because I'm gay, I don't want to be around these women dancing. I'm not interested in that in any way. Or something. Like, it takes more than just using your gayness as a blanket or a shield. They say no evidence was presented from which a reasonable trier of fact could conclude that they were an expression of actual sexual desire or intent by semen. Of course, this is an example, not directly related to Emilio, or that they resulted from Kelly's actual or perceived sexual orientation. He therefore, this goes back to him, does not allege any disparate treatment on account of his sexual orientation. Plaintiff merely alleges that as a gay man, he is not attracted to women, and therefore he attended the strip club strictly out of his duties to his employer. Plaintiff fails to state a claim of hostile work environment under FEHA merely by alleging he was forced to attend a strip club against his wishes, with no allegation that the requirement was because of his sexual orientation. Okay, a hostile work environment sexual harassment claim is not established where a supervisor or coworker simply uses crude or inappropriate language in front of employees or draws a vulgar picture without directing sexual innuendos or gender-related language toward a plaintiff or toward the protected class in general. Second, plaintiff's vague and conclusory argument that he suffered unspecified harm in California is not sufficient to allege severe and pervasive harassment for an FEHA claim. Okay? Third, as for plaintiff's allegation that he lost work opportunities in California, this would be about the bongo situation. He was no longer employed by defendant at the time of this alleged occurrence. Okay? An employee must show she was subjected to harassing conduct that was sufficiently severe or pervasive to alter the conditions of her employment and create an abusive work environment. In any event, his one allegation that he was removed from a photo shoot is not enough to demonstrate severe or pervasive hostile conduct. So because Megan did not want him there at this shoot for bongos, he wanted damages. The judge says, nah, dog. Okay? Plaintiff's allegations therefore fail to state a hostile work environment under claim FEHA. Because plaintiff fails to state a FEHA claim against Ms. Pete, plaintiff's 12th claim against the corporate defendants, which would be her companies and Roc Nation, for failure to prevent or remedy harassment under FEHA also fails. So they will be tossing this part as well. All right, because plaintiff's racial harassment claim fails. Plaintiff has no basis for, and again, these are examples, for failure to prevent and remedy harassment claim, as she cannot show that defendant failed to prevent harassment where there has been no finding of harassment. We shall continue. Now remember, the California work environment claims are being tossed, but in New York, they will largely remain. Okay? So plaintiff plausibly pleads discrimination under the NYSHRL and the NYCHRL. Plaintiff plausibly pleads that he faced a hostile work environment on account of his sexual orientation sufficient for his NYSHRL and NYCHRL claims to survive at this stage. Okay, which is very important, at this stage, which means it may not stand moving forward, but at this point, it's allowed to stay open, right? The NYSHRL prohibits an employer from discharging or discriminating against an individual in compensation or in terms, conditions, or privileges of employment because of the individual's sexual orientation, sex, or disability. To establish a hostile work environment claim under the NYCHRL, the plaintiff need only demonstrate by preponderance of the evidence that she has been treated less well than other employees because of her gender, disability, or sexual orientation. So now he's implying that he was treated the way that he was because he's gay. I don't know if that's going to stand in the court, but it will at least be presented. Okay? The plaintiff bears the burden of showing that the conduct is caused by a discriminatory motive. It is not enough that a plaintiff has an overbearing or obnoxious boss. She must show that she has been treated less well, at least in part, because of her protected characteristic. Because plaintiff worked in New York, all right, because they established that he was an employee of Megan and Roc Nation in New York due to the fact that he had to travel to her at least once a month and sometimes stayed weeks at a time while she did her meetings in New York, did shoots in New York and things of that nature. So at this stage, they are saying he is an employee. So because he felt some form of discrimination, they are going to allow this to stay alive at this point. Allegations of conduct outside of New York can form the basis for state and city human rights law claims. The New York Court of Appeals established an impact test for non-residents seeking to assert claims under the state and city human rights laws. There are two ways in which a non-resident may satisfy the impact requirement. 1, working in New York. 2, establishing that the challenged conduct had some impact on the plaintiff within the respective New York geographic boundaries. Because he claims he was uncomfortable in the New York strip club, this does fall as valid at this time. The impact test thus expands the protections of the human rights laws to non-residents who work in the state or city and to those who state a claim that the alleged discriminatory conduct had any impact in either of those locations. Here, plaintiff alleges that he spent a substantial amount of time working in New York State and New York City. He worked in New York at least once per month and sometimes remained in New York for weeks at a time. The court finds that these allegations are sufficient to plausibly plead that plaintiff worked in the state or city. Thus, his allegations of hostile work environment abroad had an impact in New York State and city. The cases cited by defendants would be Megan, Roc Nation, and her own companies, are distinguishable. Okay? In King v. Aramark, which was issued only days after Saeed and does not cite to Saeed, the Second Circuit held that the plaintiff could not prove an impact felt in New York because she spent only intermittent time working in New York. By contrast, plaintiff alleges more than an intermittent work schedule in New York. He alleges regular work each month, sometimes for most of the month. Okay? And in Hardwick versus Arima, which was issued by the First Department a decade before, the court held that the plaintiff failed to allege an impact in New York because of her work for USA Basketball Inc., blah, blah, blah. We'll just keep moving here. By contrast, plaintiff's work for Miss Pete abroad was part of and parcel of his employment for Miss Pete as a personal cameraman in New York. At this early stage in the litigation, plaintiff plausibly pleads that the alleged sexual encounter in the SUV in Ibiza created a hostile work environment based on plaintiff's sexual orientation. Defendants do not dispute plaintiff's contention that the alleged SUV incident would constitute a hostile work environment as defined under the NYSHRL and NYCHRL. So this is about the situation in Ibiza where he claims that Megan subjected him to having to see her have a sexual encounter with her friends in front of him in an SUV. At this stage, it is that situation is being protected under New York law because he was an employee in New York, not because it happened in New York. Defendants merely dispute whether plaintiff has alleged facts from which one may infer a causal relationship between plaintiff's sexual orientation and his being subjected to the incident. Now, interestingly enough, we got to see how they respond to whether or not this incident even occurred. Well, we'll move forward. Plaintiff asked the court to draw the inference that Pete would not have engaged in group sex with other women in front of a heterosexual male, that Pete felt comfortable engaging in group sex with other women in front of plaintiff because of plaintiff's sexuality and gender. I'm not sure how strong that's going to stand moving forward, but as of now, he gets protection of Megan feeling comfortable enough to perform these alleged acts in front of a homosexual male rather than if he were heterosexual. Okay? I guess of protection because he wouldn't have felt like he wanted to come on to her, whereas a straight man plausibly could have felt that way, I guess. You know, again, I'm not a lawmaker. This is not an unreasonable inference to draw from the facts alleged. Therefore, a plaintiff has plausibly pleaded that he experienced the alleged inferior conditions of his employment on account of his sexual orientation. Now, let's get to the overtime and wage statement claims. They say plaintiff has not adequately pleaded violations of California's overtime wage law. Plaintiff has not adequately pleaded. A plaintiff asserting violations of the overtime provisions must allege that she worked more than 40 hours in a given work week without being compensated for the hours worked in excess of 40 during that week. Plaintiff need not allege with mathematical precision the amount of overtime compensation owed by the employer. Instead, she should be able to allege facts demonstrating that there was at least one work week in which she worked in excess of 40 hours and was not paid overtime wages. The Supreme Court of California has held that the Labor Code's provisions apply to non-residents for work performed in California. Courts must apply California's overtime law to full days and weeks of work performed there by non-residents. Plaintiff has failed to allege that he worked overtime hours for a given day or week of work in California, probably because it was undocumented. Plaintiff merely alleges that he spent a substantial amount of time working in California, and separately alleges that during his employment he worked sometimes 16 hours a day and in excess of 50 hours per week. Plaintiff does not allege that any of these 16-hour days occurred in California, and even if the court were to interpret plaintiff's allegation to mean that he worked in excess of 50 hours every week, he does not allege that any of these weeks were full weeks in California. Plaintiff does not allege that there was at least one full work week in California in which he worked overtime hours. So California, he wanted compensation via California laws. The California laws are saying fuck out of here. But it looks like New York is keeping him alive a little bit. Okay? Therefore, plaintiff has failed to adequately plead that defendants violated the California Labor Code's overtime provisions. Plaintiff has not adequately pleaded violations of California's wage statement law. Because plaintiff has failed to plausibly plead that he performed a majority of his work in California or that he is based in California for work purposes, plaintiff fails to state a claim under Section 226A of the California Labor Code. Section 226 requires an employer to supply each employee semi-monthly or at the time of each payment a written wage statement listing the employer's name and address, identifying the pay period, itemizing the total hours worked, applicable hourly rates, hours worked at each rate, gross net wages earned, and any deductions taken, and disclosing other prescribed information. Hold on, y'all. All right. Plaintiff fails to allege either that he worked principally in California or that he had a definite base of operations in California. Plaintiff only pleads he spent a substantial amount of time working in both California and New York. Pleading that he spent a substantial amount of time in California is not equivalent to pleading that he spent a majority of his work time in California. Okay? Further, plaintiff does not allege that California served as the base of operations for his work for defendants. Therefore, plaintiff has failed to adequately plead a claim under Section 226A of California Labor Code. So California said, get the fuck out. Okay. Plaintiff fails to adequately plead a violation of the NYLL overtime provisions because he wants overtime pay for working 16-hour days and being on call for 50-hour weeks, as he alleges. They say plaintiff's NYLL claim for failure to pay overtime is pleaded with insufficient detail to cross the line to plausibility. In 2013, the Second Circuit decided a trilogy of cases which set the contours of pleading a case for failure to pay overtime wages under the Fair Labor Standards Act. Okay, so he ain't finna get overtime pay in New York either. That's basically what's going down here. The amended complaint suffers from the same deficiency identified in DeJesus. Plaintiff simply alleges that during an unspecified period, plaintiff worked in excess of 50 hours and was not compensated at the statutory minimum wage and overtime rate. Plaintiff simply added 10 hours to the very same threadbare allegation that the Second Circuit deemed a rephrasing of the statutory formulation. Plaintiff therefore fails to nudge his claim from conceivable to plausible. While the court need not reach the issue, the court also notes that, as with plaintiff's California overtime claim, the amended complaint fails to delineate which weeks and hours of overtime plaintiff worked in New York, because all of this work is not being documented. And so he has no paper trail to support his claims. Without sufficient detail about the length and frequency of her unpaid work to support a reasonable inference that she worked more than 40 hours in a given week, plaintiff fails to state a claim for overtime pay under the labor law, which applies to him. Defendants provide no basis on which to dismiss plaintiff's NYLL wage notice and wage statement claims. Okay, so defendant, of course, is Megan, Rock Nation, etc. Defendants offer no arguments beyond those already addressed elsewhere in this opinion why the court should dismiss plaintiff's NYLL claim for failure to provide accurate wage notices and wage statements. NYLL provides a private right of action for violations of sections 195.1 and 195.3, failure to provide wage notices and wage statements. Defendants failed to address plaintiff's section 198 claims separate from the arguments that plaintiff was not an employee. Therefore, the court declines to dismiss that claim. Here we get into meal and rest break. Okay, the court declines to dismiss plaintiff's claim that defendants violated the meal and rest break provisions of the California Labor Code. Defendant's only argument for why plaintiff fails to state a claim under section 226.7 is that plaintiff does not allege the reason his meal and rest periods were denied. However, the case on which defendants rely does not require that a plaintiff allege the reason his meal and rest breaks were denied. The case only held that it was insufficient for the plaintiff to allege that he skipped them by his choice. However, in this case, unlike in Bunkley, plaintiff has alleged that defendants impermissibly denied those breaks. Okay, so they saying they tried to use a case where somebody chose not to take breaks. In this instance with Emilio, he's claiming they didn't allow him to take breaks during the entirety of his employment, which one can reasonably infer includes his time in California. Therefore, defendant's motion to dismiss the 13th claim of the amended complaint is denied. So now we get into retaliation, okay? Plaintiff adequately pleads a retaliation under the NYSHRL, NYCHRL, and NYLL. Plaintiff sufficiently pleads claims for retaliation. The NYSHRL prohibits retaliation against any person because he or she has opposed any practices forbidden under this article or because he or she has filed a complaint, testified, or assisted in any proceeding under this article. The NYCHRL is materially identical. NYCHRL prohibits employers from retaliating or discriminating in any manner against any person because such person has opposed any practice forbidden under this chapter. Okay. Similarly, NYLL provides in pertinent part that no employer shall discharge, threaten, penalize, or in any other manner discriminate against any employee because such employee has made a complaint to his or her employer that the employer has engaged in conduct that the employee reasonably and in good faith believes violates any provision of the NYLL. And of course, he claims that he was retaliated against for making complaints to another worker under Megan. Plaintiff must plead 1. Participation in protected activity known to the defendant, adverse employment action affecting the plaintiff, and 3. A causal connection between the protected activity and the adverse employment action. NYLL 740, often referred to as New York's whistleblower law, prohibits an employer from taking any retaliatory action against an employee because such employee discloses or threatens to disclose to a supervisor or to a public body an activity, policy, or practice of the employer that the employee reasonably believes in violation of law, rule, or regulation. Under the statute, a plaintiff must first allege that she disclosed or threatened to disclose to a supervisor an activity, policy, or practice of the employer that the employee at least reasonably believed was illegal. The plaintiff must then point to a retaliatory adverse action taken by the employer in response to that complaint. As a result, for an employer to fall afoul of the whistleblower statute, the adverse action must have been taken because the employee engaged in protected activity. In other words, the whistleblower statute requires some causal connection between an adverse personnel action and a report of illegal activity. So, protected activities. Plaintiff adequately alleges that he engaged in protected activity when he confronted Miss Pete about her treatment of him during the Ibiza incident and about her failure to pay plaintiff the wages he is owed. The court is sympathetic to defendant's argument that plaintiff's allegations that he opposed Miss Pete's unlawful conduct and opposed defendant's unlawful wage practices are rather vague. So the judge is acknowledging that his claims are vague and nearly threadbare recitals of the elements of the claim. But defendants are incorrect that plaintiff must allege that he specifically identified the unlawful conduct to be discrimination. Rather, the New York Court of Appeals has held that opposing any practice can include situations where a person, before the retaliatory conduct occurred, merely made clear her disapproval of the defendant's discrimination by communicating to him in substance that she thought his treatment of the victim was wrong. While plaintiff did not say in so many words that the Ibiza incident was discriminatory, he made clear to Miss Pete that the conduct was unlawful and wrong. At the pleading stage, the court finds this allegation sufficient to constitute a plausible protected activity, meaning the claim will move forward. Likewise, plaintiff's allegations regarding his opposition to alleged improper pay adequately put his employer on notice that he is asserting statutory rights. Plaintiff alleges not that he told Miss Pete his pay was too low, holding that complaints that pay was too low or not sufficiently clear in light of both content and context as an assertion. Rather, he alleges that he told Miss Pete that he was not being paid all of the wages owed to him, which plausibly implies an assertion of statutory rights. Okay, so they're basically stating that he was saying, hey, this is an unlawful practice. Okay, he was acknowledging his rights. Additionally, he alleges that he challenged her purported unlawful wage practices. The court therefore finds that the plaintiff has adequately pleaded that he engaged in protected activity in opposing violations of the NYSHRL, NYCHRL, and NYLL. Causal connection to retaliatory conduct. Plaintiff has alleged facts sufficient to infer a retaliatory motive for the adverse employment actions at the pleading stage. Plaintiff alleges that after he complained to Ms. Pete about the allegedly harassing incident in Ibiza, and after she threatened plaintiff to never speak about it, he was booked less frequently than prior to the incident. Okay, so because he was brought around less after allegedly voicing his problem with whatever took place in Ibiza, they're saying that this, at this particular stage, can qualify as retaliation. And only 2 months after complaining about the Ibiza incident, defendants changed his compensation structure, which that he earned less for the same amount of work. Now that part I don't think is actually clearly indicated in his complaint, because they actually were using him less, so it couldn't have been the same amount of work. But anyway, these facts raise a reasonable inference that material terms and conditions of plaintiff's employment were altered in retaliation for speaking up about the incident. Okay? And plaintiff's allegation that he was fired within weeks after complaining to Ms. Pete about alleged wage violations is sufficient to infer a causal relationship for purpose of his NYLL retaliation claims. Okay, so he complained. Weeks later, he was fired. He complained a few times along the way, but after these complaints, he was let the fuck go, and he wants compensation. Extraterrestrial application of the NYLL's retaliation provision. Defendants cannot at this stage defeat NYLL retaliation claim by arguing that the conduct occurred outside New York State's geographical boundaries. Okay? So he's protected by New York law at this time. The potential choice of law question in determining whether plaintiff may invoke the NYLL's retaliation protection is fact intensive and premature to resolve at the motion to dismiss stage, which means that later on it can be evaluated again, but at this stage it will live on. At this stage, plaintiff has alleged that he worked in New York consistently, and as a result of his termination, which he alleges was retaliatory, he lost his New York employment. The court declines to hold that plaintiff is barred from invoking the retaliation protections of the NYLL at this stage. Keyword at this stage. 3. Plaintiff plausibly pleads that defendant's retaliatory conduct occurred in California sufficient to state a claim under the California Labor Code. Because plaintiff alleges that the decision to terminate him was made in California, so this is about his firing, the court declines to dismiss the retaliation claim under California Labor Code 986 1102.5 on those bases. California Code Section 1102.5 forbids an employer from retaliating against an employee for disclosing information to a manager or other employee with power to investigate a violation or noncompliance if the employee has reasonable cause to believe that the information discloses a violation of law. Similarly, California Labor Code Section 98.6 prohibits an employer from retaliating against an employee for engaging in any conduct delineated in Chapter 5 of the Labor Code, which includes Section 1102.5. Plaintiff alleges that the decision to wrongfully terminate him after he complained about wage and hour violations was made by senior management supervisors and HR officers physically located in California. He has therefore plausibly pleaded that sections 1102.5 and 98.6 apply in this case. Okay? So it's possible he may be compensated for wrongful termination. Now, as for aiding and abetting claims, plaintiff fails to adequately plead New York aiding and abetting claims against the corporate defendants. Because plaintiff fails to allege that the corporate defendants shared Ms. Pete's alleged discriminatory and retaliatory intent, plaintiff fails to state New York State and city aiding and abetting claims against the corporate defendants. Of course, corporate defendants is pretty much Roc Nation. So they won't be held liable for Megan's discriminatory retaliation. Both the NYSHRL and the NYCHRL make it unlawful to aid, abet, incite, compel, or coerce the doing of any discriminatory or retaliatory acts under the statutes. Okay? The amended complaint is devoid of any allegation that the corporate defendants had any knowledge of or intent to aid or abet the discriminatory and retaliatory acts alleged. Plaintiff does not allege that he reported any of the discriminatory or hostile conduct to the corporate defendants, meaning he never told Roc Nation he was uncomfortable. Rather, he alleges that until he finally confronted Ms. Pete about his wage complaints during the June 2023 phone call, he remained silent about the unlawful pay practices and acts of retaliation. Okay. The amended complaint does not plead that plaintiff made any complaint to defendant during their alleged harassment. All right. Prior to the June 2023 phone call, he alleges that he confided only in Alex, a makeup artist, and plaintiff does not allege that he reported any of his complaints to the corporate defendants after the June 2023 phone call. That Roc Nation and the other corporate defendants were allegedly involved in the termination does not support a claim for aiding and abetting where there are no allegations that they were aware or shared Ms. Pete's discriminatory or retaliatory intent. Plaintiff offers nothing more than conclusory recitations of the legal standard that would suggest that the corporate defendants were aware of Ms. Pete's conduct or otherwise had an intent to discriminate or retaliate against plaintiff. They say no, as in the judge. Plaintiff adequately pleads aiding and abetting claims against Ms. Pete. How can she aid and abet her own decision? Well, I guess it's explained. Plaintiff's allegations are sufficient to state a claim for aiding and abetting liability against Ms. Pete. While generally a person cannot aid and abet his own wrongful conduct, that's exactly what my question was, the NYSHRL and NYCHRL extend personal liability for aiding and abetting allegedly unlawful discrimination by an employer, even where an individual defendant's actions serve as the predicate for the employer's vicarious liability, so long as the employer's conduct also has been found to be discriminatory under the NYSHRL. I read that shit and it don't make no more sense. Because plaintiff has alleged that Ms. Pete committed acts of unlawful discrimination and retaliation, liability for which is imputed to the corporate defendants, plaintiff adequately states a claim against Ms. Pete for aiding and abetting. That sounds like a load of bullshit to me, but that ain't, hey, I don't make the law. So here we have leave to amend. Defendant's motion to dismiss are granted in part with leave to amend as scheduled below. The court should freely give leave to amend when justice so requires. However, leave may be denied for good reason, including futility, bad faith, undue delay, or undue prejudice to the opposing party. Plaintiff fails to adequately allege facts sufficient to plausibly plead FEHA claims, overtime and notice claims under the California Labor Code, overtime claims under the NYLL, and aiding and abetting claims under the New York Human Rights Law as it pertains to Roc Nation, that is. The court cannot conclude that further amendment would not cure these deficiencies in the amended complaint. The court therefore grants plaintiff leave to file a second amended complaint solely to cure the deficiencies identified with respect to these claims no later than 30 days from the date of this order, which means that Emilio and his legal team are now given the opportunity to state a new claim, right? Well, I ain't gonna say state a new claim, but they can amend their claim, which means that they can make revisions where needed to reflect what the judge has taken out and what the judge has allowed to continue. Okay? Conclusion. For the foregoing reasons, defendant's motion to dismiss are granted in part and denied in part. The following of plaintiff's claims are dismissed without prejudice, with leave to amend as described above. Claims 3 and 6, NYSHRL and NYCHRL aiding and abetting as to the corporate defendants. Claim 9, NYLL wages and overtime. Claim 7 and 12, FEHA. Claim 15, California Labor Code overtime. And Claim 16, California Labor Code wage statement. Plaintiff's 13 claim for misclassification under California Labor Code sections 226.8 and 2750.3 is dismissed with prejudice. The motions to dismiss are denied with respect to plaintiff's remaining claims. Okay? Now, let's spend a little bit of time here, not much, but a little bit, discussing Nicki Minaj and what she's doing as of today. All right? So I'm actually on Nicki Minaj's Twitter page. Number one, she's quote tweeting Academics TV. No Spin TV, which is full of spin, fully spinned narratives. I'm sure she wouldn't like a lot of the stuff if it were about her on Academics TV, but as of now, she's quote tweeting this piece here. We just went over this. They say the judge has denied Roc Nation and Megan Thee Stallion motion to dismiss a lawsuit where her homosexual cameraman claims the twerker the twerker, forced him to watch her have a freak off. What? Have a freak off car sex with a woman inside a moving car while on tour in Ibiza, Spain in 2022. Why anybody gives these people the time of day is lost upon me. Judge Wood says the cameraman, who is gay, plausibly pleads that the alleged sexual encounter in the SUV in Ibiza created a hostile work environment based on plaintiff's sexual orientation. As you can see, they're only spreading a piece of what was actually stated by the judge. Okay? So they don't talk about what's being tossed out. They only speak on what's moving forward. So here we have, damn, she been on for longer than I thought. So one tweet here says Spotify charts looking scary. She comes back and says it was all good just a week ago, which is a direct quote of Jay-Z. And she's been shooting at Jay-Z for weeks and months. So Nicki comes in and says, oh no, what was that law again? And of course, the law she's referencing is Megan's Law from, Hiss. But laughing at this doesn't make that law any less any less active. And it doesn't make the claim any less effective. But, emotional victories or temporary victories in that regard, you still with that dude. Cause that bar wasn't even about you, really. It's just by association. Anyway, moving forward, we have somebody here saying something really woke up the Barbs this time. No one has known peace for weeks. Feels so good to have everyone back. So this is where they're talking about the Barbs getting together, terrorizing people online like they used to do back in the old days. Nicki Minaj gets a good laugh out of that. Someone else says, I knew TSR was going to be quick. Strap y'all shoes on. TSR as in the Shade Room. I'm not necessarily abreast of what the Shade Room did. I don't really check them. But Nicki says, okay, well, let's see if they're quick about the next one. TSR, would you like to be placed in a lawsuit for knowingly posting lies and using bots, allegedly? Okay, so now she's threatening to place the Shade Room in a lawsuit for knowingly posting lies, she says, and using bots. I don't see how using bots on a social media page would be illegal, but, I'll digress. Here we have a direct retweet from Nicki about the Jay-Z Raymir Stoudemire guy. This is the guy who claims Jay-Z is his father. She posts this thing from 50. She says, is this why he was trending the other day? I don't know. To God be the glory. So Jay-Z is everything but a child of his mama. Nicki claims that Jay-Z and Roc Nation or Tidal owe her money. But because he owes her a few dollars, she is now leaning into trying to destroy his reputation, his company, and his good name in the public for things completely unrelated. She retweets, TSR fell for the plot. Nicki really baited them. I don't think y'all understand. She says, Barbs, let's trend. Jay-Z again before I go to Twitch or Kick. Okay. She posts this meme here of her and NBA Youngboy of all people. Ain't he a domestic abuser? Anyway, I don't know about this before I go to Twitch or Kick thing. If she starts streaming on Twitch and Kick, oh my goodness. That's going to be a doozy. There's more. This is a direct reference to the Megan Thee Stallion lawsuit with Emilio. She says being a gay man doesn't give any woman the right to sexually grind on you or have sex in front of you. I remember seeing someone grinding on their hairstylist and he seemed so uncomfortable. Okay? Ain't the hairstylist Kellen? He seemed to be having a great time. But anyway, maybe it could be the old hairstylist. I don't know. Y'all let me know. I'm not abreast of all of these details in minutia. But she's siding with Emilio. She continues to retweet her fans. We got another one going at Jay-Z. Jay-Z, touch not my anointed. It didn't say touch not my informant in Legal Shark. It didn't say touch not my industry piranhas. It didn't say touch not the folks that do some good stuff to cover their evils. Let's talk about it. Okay? We've got another one. Jay-Z is not impervious to criticism. Ain't nobody God here. Word to the baby in the manger. This is black exceptionalism run amok. Have several seats. You will not get away with the dirt in your closet like none of us can. Some dirty closets around here. And here she goes direct. She says, we've calculated about 100 to 200 MM so far. Now, I don't know what she's talking about, MM. She could be talking about $1 million. I would doubt it. But, again, you never know what the fuck she's talking about. She says, Jay-Z, call me to settle this karmic debt. I'm sure if you would have called Jay-Z or asked him to call you before all of this happened, y'all could have had a conversation. But that's not on me to determine. She says, karmic debt is only collecting more interest. She says, you still in my top 5 though. Let's get it, nigga. And anyone still calling him Hove will answer to God for the blasphemy. And I think she actually has lyrics calling him Hove. But I will digress. She says, I'm going to use some of the money Jay-Z owes me to send some of my barbs to college, pay their school fees and student loans via my Student of the Game charity. Okay? So she's still shooting at Jay. She then says, depose Deseret. Okay? As in Desiree Perez. She calls her Deseret. Emilio has been trying to get the courts to depose Desiree of her involvement in his employment. Nicki says, depose Deseret. She says, if you get a message to post or hate lies today on any platform, I'd advise you to say no. They won't cover your legal fees. Just today alone, we've added 5 blogs and 5 content creators. I hope you got a lot of money saved up. Hope it's worth losing everything, including your account. Okay, so Nicki is now threatening a lawsuit. Perhaps she's going to sue Jay-Z and Roc Nation. Okay, this is something that I've been waiting to see because she's been complaining about Jay-Z for a while, but there was no actual legal paper trail. But now they're talking about adding 5 blogs and 5 content creators to the lawsuits. Okay, for posting lies. She says, LOL, this didn't go the way they intended. Every time you try to get the attention on me for your own financial gain, it'll go back on the things you don't want it on. Oh, and there's a lot more. Trust it's all fun and games until I want to play too. She then puts a poll up for Kick or Twitch. So she's really serious, it seems, about going to a streaming platform. Now, I do know that she was complaining about Instagram a few days ago. I didn't talk about it. But she was basically alluding that Roc Nation or somebody that was in bed with Roc Nation was basically blocking her views on IG Live. Okay? She felt that the views were distinctively low, lower than she's accustomed to. And she felt that there was something at play trying to hold her back once again. So now she's talking about going on either Kick or Twitch to start streaming direct to her fans. Okay, that is the end. No, it is not. There's more. Hold on, this a bunch more. Fuck. T with Tia says the judge granted a single deposition of Desiree Perez, but it is limited to 3 hours within the next 2 weeks. Rock Nation is checking her calendar, but says she should be available, but will let the court know if she can't make it. Rock Nation does not agree with the time frame and feel it's excessive and says she is the CEO with a busy schedule, she is, and want the deposition to be 2 hours. They said her involvement was minimal and the 3 hours is not appropriate. The judge said he didn't have enough information, so that request is denied. He, however, asked Emilio's counsel to conduct the deposition in a good manner and not harass Desiree. Okay? So she then posts the Joker as she's reading from a blog that spreads misinformation pretty consistently, but, you know. She says, what, is this true? I'm learning so much about my rights, LOL. So you get to decide how long your deposition is? Haha, isn't this the lady being accused by her daughter of being racist against black people, Jay-Z? There was no black woman smart enough to be the CEO of your company? What happened to Shaka? He gonna go take a pic with Shaka now? LOL. Oh, Jigga, man, the jig is up. Shaka has a very important position in Rock Nation too, though. Anyway, we'll move forward. She says, Dear Jay-Z and Deseret, you ruined hip-hop. You said Jay-Z ruined hip-hop? Get the fuck. She says you ruined football, because, you know, Rock Nation went into sports. You ruined basketball. You ruined touring. How did they ruin touring? By just having a fucking partnership with the touring company. You ruined Instagram. Oh my God. You ruined Twitter. The jig is up. All of this is alleged and for entertainment purposes only. I'm guessing her lawyer must have told her to put that up as a disclaimer. Ask Milagro how those disclaimers work. She says, Jay-Z, you let Deseret do a lot of evil to black people and you stayed silent. We used to believe you. You went out sad, nigga. This is all alleged and for entertainment purposes only. Deseret, did you get that 40 mm? 55 and paying for bots? Oh, Bot Nation. Oh, they calling them Bot Nation now. Clever. She comes back. So let me get this straight. Y'all so-called black savior Jay-Z has a Hispanic CEO who was pardoned by President Trump. Interesting. So does that mean Deseret isn't a Democrat? Oh, she trying to rhyme on your ass now, sir. Black people, I thought y'all hate all Trump supporters. Wait, did Jay-Z ever campaign for Kamala? He's benefited so much from the party. Ma'am, did you campaign for anybody? You trying to play political now? Ma'am. There's more I could say, but I'd rather not. When President Obama gave the speech about brothers, why didn't Jigga Man come out and strongly campaign for the Democratic Party at that time? His wife did. Could it be that y'all have been hoodwinked? LOL. Woo-wee. That was so kind of President Trump, and that was so kind of President Obama to passionately go out and campaign it. But what did Mr. Jigga Man do to help y'all win the election? He's above speaking out to help his party? Or was it not his party? Is it just about who can benefit him and Deseret at the time? Oh, black people. It looks like the Jigga Man and Deseret played y'all once again. LMFAO, the jig is up. Now, if we were to dig into your political ties and who you voted for, I'm sure, if you voted at all, it wouldn't be what we would think. She says, Deseret, were you out marching with your fellow Mexican immigrants? Oh, right. You were pardoned by President Trump, so you kind of can't, right? I mean, it kind of implies you guys are cool with him while y'all seem to pretend to be against him. Or are y'all not his friend either anymore, just like Diddy? Oh my fucking goodness. I mean, if someone pardoned me, we'd be friends for life. Are you still friends with Diddy? You've done so much evil to black people now, you've turned your back on your own as well, it seems. Don't you guys over there keep black artists fighting while you sit back and benefit from both parties? If I had gotten a pardon from President Trump, imagine the uproar. Yet the Roc Nation CEO does it, and yup, you guessed it, silence. Black people, until you speak on this, you can never, ever, ever, ever. I wonder how Deseret thanked President Trump for that kind gesture. LOL, got a Hispanic woman allegedly calling her son-in-law a inner under the protection of y'all, so-called black savior, while y'all sit around making them rich. When y'all needed them the most, they were silent though, huh? Chin up. Jay came out to perform recently once that legal stuff started coming out, yet when Obama was pleading for the brothers to vote for Kamala, the rich and most influential black rapper was nowhere to be found, as if he's a full-time rapper right now. Maybe I'm forgetting, I don't know. Did he even say one word? It seemed like an urgent request by the tone of Obama's speech, yet Brother Billionaire never got in the field for y'all, huh? When y'all needed him the most, after all that money he made off the Democratic Party. Brainwash black people. Those blogs won't be here a year from now either, so enjoy. So she's threatening the blogs to take them down. So wait, Jay-Z had Not Like Us playing at the Super Bowl after his CEO was pardoned by President Trump? We got to find out who is they. President Biden posting Not Like Us after Deseret was pardoned by President Trump is so... She's still going. Guess who just got a brand new weird case? I guess she's about to learn the law now. Wow the fuck out. Now, if people start reversing the Uno card and asking her the very same questions about her political affiliation, connections, who she voted for, I don't recall ever seeing her advocate for anyone politically. But now you're trying to make a political statement to go against Jay-Z. Okay, now she's actually name dropping Not Like Us, which we know the contents of Not Like Us, which I find to be very ironic that you would mention that song with the person living in your home. I just find it ironic. Y'all, you know, hey, man. Shit is getting tricky out this motherfucker, man. Now, I'm sure she's probably in the process of saying even more as I speak, but at this point, I have to go. I have to get back to my family, have other things to tend to. But let me know what y'all think of all of this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel. Vote for your boy on the Global Citizen Festival. It is in the link below. And I will catch y'all on the next one. Probably catch y'all tomorrow, all right? Much love and respect. Y'all be good out there. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more to survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.